So welcome everybody to this webinar hosted by the Mount Vernon Springfield Chamber of Commerce. We're just delighted to have Mark Viani and Doug Taylor with Kinney Korman to update us on some of the things that are happening with employment law, new regulations from the federal government. So let's just start out and do some introductions, and we'll end with Doug and Mark. So Indra.
Morning, Indra Bauza. My company is Supporting Strategies. We do outsourced accounting, bookkeeping, controller level services for small, medium-sized businesses. So anything in accounting department would do payables, receivables, reconciliations, reporting, all kind of fun stuff, accounting.
Paul. And we have Paul Dean. There we go.
Yeah, hi, sorry about that. Yeah, Paul Dean with the Dean Law Firm. Wills Trust and Estates, but I guess more relevant for this discussion is I provide general counsel services to small businesses.
Very good. And Chris, do you want to introduce yourself?
Sure. Hi, good morning. I'm Chris Richardson with Kinney Korman. I work with Doug and Mark and help coordinate events such as this as marketing manager for the firm.
All right, Mark, take it away.
Good morning, everybody. I'm Mark Viani with Kinney Korman. With me is my colleague, Doug Taylor. And today we're here to talk about, kind of recent developments that, the employers need to take into account, and changes in federal law. Who has the PowerPoint?
I do.
Okay.
Are you ready for it?
Yeah, I guess we are. And I'll let my Doug kind of give his entry while we're pulling that up real quick.
Sure. Doug Taylor, happy to be presenting here today. Thanks to Holly and the Chamber, to my colleague Mark, who I do a lot of work with collaboratively, and I'm happy. I think this is the first time we've presented together, so this is a treat. And also big thanks to Chris Richardson, our marketing manager, who did a great job putting together the materials for today. My area of practice is management side employment law. So I do a lot of work both in the policy area for small and emerging businesses, litigation in the HR realm as well, and also do work with executives on compensation and pay.
All right. Let's go to the next slide real quick.
Yeah, I'm trying to get this to start up. Let me just stop sharing just for a minute. I'm sorry, I can't get it.
Oh, take your time. We're all good.
All right.
Oh, it's much better. Well, let's go to the next slide then. Just a brief overview of Kinney. We are kind of a medium-sized, Northern Virginia law firm focused mostly on business side. Our representation, founded in Arlington, 1959. I'll let you kind of read everything that you got there, but essentially we just, a lot of us were other big firms, have joined over here. You handle a lot of fairly sophisticated matters. But it's a very happy place. We work in Maryland, DC, and Virginia. I know I do too. Doug works with me on a lot of things. We represent, everything from small clients to very large clients, international clients, everything from general corporate work to, real estate, business, banking, you name it. Let's go to the next slide real quick. This is kind of the areas of law that we're primarily focused in these days. And with that, next thing I'll take it away and hand it over to Doug.
That's great. Thanks, Mark. So today we're going to cover 3 issues, and these are really these are pretty huge changes, and they are either on the verge of becoming effective. In the case of the Department of Labor rule, it becomes effective next week. Corporate Transparency Act is now in effect, and there are some different filing requirements there. So these are, for those of us in management side employment law, advising businesses, these really are sea changes that are eye-opening in a lot of ways. So we're going to talk about some of the highlights or lowlights, depending on how you look at these. And then at the end of things, hopefully we'll have some time to answer any questions that you have. So today's agenda, we'll talk about the FTC's ban on non-competes for U.S. workers. The U.S. Department of Labor's rule raising the standard salary level for exempt from overtime status, and that involves the Fair Labor Standards Act. And then we'll close by talking about the Corporate Transparency Act and how that works and what is required in the way of filing by businesses. So next slide, please. That's great. So, yeah, well, let's start with the FTC ban on non-competes. This one, for many of us, and I'm sure for business folks as well, this was a real eye-opener. Yeah, it's interesting. Didn't really connect the FTC with non-competes for U.S. workers. Readily before January of 2023, when the FTC issued a proposed rule that would essentially ban non-competes in almost all forms for U.S. workers. And so we're gonna talk about that. This all stems from back in 2021, President Biden issued an executive order. The theory being that it was supposed to promote competition in the American economy, and it essentially orders the FTC to engage and use its rulemaking authority to, to take on employer use of non-competes on the theory that they're anti-competitive. They create an anti-competitive environment for U.S. workers. It results in the inability for workers to easily move between employers. It suppresses wages, among other theories. Now, you can, in the proposed rule back in January, there was a lengthy sort of explanation of sort of how we get to this point. So if you're interested in the FTC's rationale or sort of where it gets this, the notion of non-competes being anti-competitive for U.S. workers, that's a good place to start. It's a fascinating read. Don't know that I agree with all of the theories, but there it is. So the FTC is an independent federal agency. It's been around for more than 100 years, and it's primarily tasked with promoting the enforcement of civil antitrust laws, the Clayton Act, and in the case of what we're talking about today for the final rule, the Federal Trade Commission Act. And under Section 5, it broadly prohibits unfair methods of competition. So that gets us to the next slide, and let's talk about what that means. So the FTC claims its authority under Section 5. And again, it's because the rationale that non-competes for workers are anti-competitive. The concern, I think, for a lot of people, including for this discussion, is that this is sort of a new source of authority for the FTC. Never before has, in its more than 100 years, has it claimed authority to regulate non-competes. So leaves a lot of people scratching their head as exactly where that came up. And of course, with that in mind, it raises the questions whether the FTC really has the authority to engage in rulemaking of this kind when it is so widespread. It affects, by the FTC's own estimate, more than 100 million U.S. workers are subject to some form of non-compete. And so when you're talking about, rulemaking that has that broad an impact, it raises a lot of concerns on a lot of fronts. And so we now have some litigation pending, and that is working its way through the courts. We may know something as early as next month about whether whether the FTC rule will go into effect. The effective date is September 4th, but stay tuned for more on that. Next slide, please. So basically, how does this new rule work? And there really are two things. September 4th, 2024 is the effective date for the rule. So we've got non-competes that are effective before September 4th, 2024, and then non-competes that that might be made after September 4th, 2024. And they're treated slightly differently. For existing non-competes, those in existence before September 4th, the new rule invalidates them all for all workers except senior executives. And senior executives has, you know, in my practice, I view senior executives as anyone sort of at the vice president level on up. But this is a more specific meaning than we would typically give to senior executive. And in the final rule, it's really defined as an individual earning more than $151,164 annually. But the big one is it has to be a policymaking position, and this is essentially a C-level policymaking position, an individual who has policymaking authority for the entire company. So if, you know, for example, you've got the, you know, vice president of marketing for, you know, for a business, that I think would not meet the definition of senior executive here as the FTC uses it. And just to show how narrow it is, the FTC estimates that it's applicable to fewer than 1% of workers. So we've got the existing non-competes. They all go by the wayside except for senior executives as that is defined. After the new rule goes into effect on September 4th, there are no new non-competes for either senior executives or all other workers. There are essentially no non-competes after that date. So that's the big effect of the rule, and we're going to talk about some of the terms, the terminology that's used here. Next slide, please. So we've got, how about one more slide? Okay, so after September 4th, it will be unlawful. It'll be a violation of the FTC Act to enter into or attempt to enter into, not only do it, but even to ask a worker for a non-compete after September 4th, in theory, violates the FTC Act. After September 4th, you can't enforce or attempt to enforce a non-compete clause, and you can't even represent to a worker that they're subject to a non-compete after September 4th without running afoul of the FTC's new rule. So it's pretty broad prohibitions, you know, once the rule goes into effect. Some of the key concepts under the new FTC rule. And I want to read the definition of non-compete because I'm sure many of you have an idea about what that entails. The FTC's version of non-compete, I think, is broader than we usually think of those things. So the final rule defines non-compete as a term or condition of employment that either prohibits a worker from, penalizes a worker for, or functions to prevent a worker from seeking or accepting work in the U.S. with a different person, where such work would begin after the conclusion of employment that includes the term or condition, or from operating a business in the United States after the conclusion of employment that includes the term or condition. So this is really this is really a broad prohibition in the sense that we think of non-competes as, you know, in some ways competing with with a former employer for the same or similar set of services in a particular geographic area, perhaps, and so forth. But non-compete, as the FTC defines it, is really broader than that. And we're going to talk about this a little bit in the context of non-disclosure agreements or confidentiality agreements and non-solicitation agreements. And this is where you'll see that this idea of non-compete kind of has a broader connotation than we usually think of it. So for confidentiality agreements or non-disclosure agreements and non-solicitation of both your customers and other employees, under the FTC rule, those things are not de facto a violation of the rule, but they can be if they are. I'm going to call it if the non-solicitation or non-disclosure is the functional equivalent of a non-compete agreement, then they're also banned under the new rules. So you can see you've got non-competes, confidentiality agreements, which many businesses use, certainly non-solicitation of customers and other employees, very commonly used. And under certain circumstances where they would be so comprehensive, if you will, then you really are going to find at least some argument that they function as a non-compete and could violate the FTC's new rule. We think that there is a workaround for most businesses for the new rule, in that because in particular non-solicitation agreements, but also for confidentiality agreements, as long as they're carefully crafted so that they don't extend beyond what the particular business needs to protect their interests as a business, we think that they function just fine in keeping with the FTC's new rule. So we've been focusing a lot of attention working with clients on on carefully considering the wording of their non-solicitation agreements and confidential information or non-disclosure agreements to be sure that they're narrowly tailored and likely to be usable even if the new FTC rule goes into effect. Training repayment agreement provisions, or TRAP agreements, are basically agreements some employers use where an employee will be required as a matter of an agreement to repay certain costs the employer in the event that they leave, or in the event that they compete against the employer in a new job once they leave. And I think it's still a TBD as to what extent those kinds of TRAP provisions will be enforceable under the new rule. I think it depends on the facts, the particular circumstances, but just be aware that while those provisions are not per se a violation of the new rule, they do present some concerns. Worker is also an interesting concept under the non-compete bans. When I think of worker, I typically think of it as the equivalent of employee. But here it's more than that. The FTC says the new ban on non-competes applies to independent contractors and other sort of sole proprietorships, volunteers, and so forth. So it really is a broader concept than when you're thinking about it just applicable to just your employees. In the FTC's view of the world, it's much broader than that. Next slide, please. So we've got some written notice requirements, and this is something that you'll need to prepare for. You've got to provide express written notice to current and former workers, except in the case of senior executives who have existing non-competes, and you have to do this before September 4th, and you have to inform them the non-compete cannot and will not be enforced. Notice can be provided by a number of different means, and you have to do that for all, for all existing non-competes, all sort of existing enforceable non-competes, unless you simply do not have any contact information for an employed. So this is important. I recommend that you keep records of what you do here and make sure that it goes out in a way that you can prove, if called upon, that you've provided the written notice. Next slide, please. Penalties for violating the new rule. They're somewhat convoluted, subject to sort of the FTC's authority to issue an injunction. There is administrative adjudication before an administrative law judge. And in the case of a ruling that's unfavorable to either business or the FTC, it can be appealed to the full commission. At the end of the day, though, the bottom line is that there are civil penalties that can be issued, including injunctions against further enforcement of your agreements with your employees. So it's not insignificant, and since this is sea change, we're seeing a lot of interest from clients in revisiting their employment agreements for compliance with this. So next slide, please. Also, too, we touched on this briefly. We don't know whether there's going to be some judicial injunction issued before September 4th, but in any event, for those of you doing business in the DMV, there are state law restrictions on use of non-competes with I call them low-wage employees. I don't know whether for Virginia 73,320 is really low wage in the overall scope of things, but be that as it may, that's the Virginia's benchmark. For DC and Maryland, where Mark mentioned that we practice, the numbers are higher. And so, those bans are still, in effect, and they will be, even if the FTC, new FTC rule is stayed. Next slide, please. And one last thing, some breaking news for you here. If this wasn't all enough, even if the FTC rule doesn't go into effect, as a business owner, you have to contend with the National Labor Relations Board, who an NLRB administrative law judge decided probably going on 2 weeks ago now in the J.O. Mori case that that restrictive covenants, non-competes in particular, violate the National Labor Relations Act. So again, it feels like non-compete restrictions are under attack on a lot of fronts. So our best advice to you at this point is, if you're going to use them, you should have a really good reason for doing it, and it should be done really carefully with an eye toward where we stand with these new rules and the state laws that you need to comply with. Next slide. So now we're going to switch topics and move over to the Department of Labor passed a final rule earlier this year that goes into effect on July 1 that increases the standard salary level under the Fair Labor Standards Act. Next slide. So the title of the new rule is a mouthful: defining and delimiting the exemptions for executive, administrative, professional, outside sales, and computer employees. As I mentioned, it becomes effective on July 1. What does it do? Next slide, please. So, it requires an explanation of what the Fair Labor Standards Act is, because the new rule really is an amendment to that act. As many of you know, the FLSA essentially sets hourly minimum wage and overtime pay for non-exempt, and that's usually hourly pay, employees. And many of you may know, employees who are non-exempt must be paid overtime for any hours worked over 40 in a week. Conversely, in order to be exempt from overtime under the FLSA, there are three things that that must be satisfied. One, the employee has to be paid on a salary basis, which means they get a set amount each week. It's not subject to reduction because of variations in quality or quantity of work performed. They've got to perform primarily perform EAP, executive, administrative, or professional duties, and currently be paid at least a standard set weekly salary level, which is at $35,568 annually, or $684 per week. Next slide, please. So I forgot to mention from the last slide, highly compensated employees are also exempt from overtime, and we'll talk about what that means. So What does the new rule change? It changes only the standard salary level. So as of July 1, the standard salary level for exempt status goes up to $43,888 annually, and that's $844 per week. And then it's 6 months later, January 1, 2025, it goes up again to $58,656, $1,128 per week. That's a pretty significant jump in the space of 6 months. Subsequently, the beginning on July 1, 2027, the Department of Labor will adjust the minimum salary level every 3 years to reflect current earning data to adjust for inflation, among other things. For highly compensated employees, the current salary level for exempt status is $107,432 annually. July 1, that goes up to $132,964. And on January 1, 2025, goes up to $151,164. Importantly, it doesn't change any of the other parts of it. There are no changes to the standard duties test, so you've still got to consider whether a particular employee is primarily performing duties that are exempt under the EAP duties tests. Next slide. So how do you prepare for the new rule? It's a good idea, if you haven't done so already, to really take a critical look at your workforce. If you've got salaried workers who are at or near the exempt, the standard salary level now, or they will be in the future. Now is the time to take a look at those to see what you may want to consider doing in terms of either converting. You can always convert an exempt employee to non-exempt and just pay them on an hourly basis. That makes more sense for your business. You can, if you've got an employee currently exempt who will fall below the new standard salary level, you can raise their salary to comply with the new rule. Just be aware that you've got that two-step raise coming up, so you need to think forward to January 1, 2025. There's some interesting issues to consider when you are thinking about whether to sort of reclassify your employees. I had this in a big way recently with an employer. We were conducting a workforce audit and making some adjustments to classifications for fairly large categories of employees. And I was really struck by how many of those employees were actually the exempt employees who were reclassified to non-exempt. There were in a number of instances, they were genuinely upset at being reclassified, even though you can explain to them, well, it means more money potentially because you're now eligible for overtime. You won't be making any less money as a general matter, but it's kind of the thought of now you no longer have exempt status. You're just an hourly worker. And so it's something, employee morale and really messaging, if you decide to reclassify workers, is extremely important. It's also important to give appropriate training to your managers and to employees, in particular in the area of timekeeping. As you know, for non-exempt workers, timekeeping is essentially important under the Fair Labor Standards Act. And you may have exempt employees who simply have not been ever really asked to timekeep, and will need to be prepared for how to do that under whatever time tracking system you use. Next slide, please. So, and now the final topic is new reporting requirements under the Corporate Transparency Act. Next slide, please. So this is new. The Corporate Transparency Act went into effect on January 1, 2024. It's enforced by the Crimes Enforcement Network, FinCEN, which is a subset of the Department of the Treasury. The theory is to bring transparency to corporate structures, domestic and foreign, that are operating within the United States. The idea is that it provides the regulatory authorities with the information that they'll need to sort of combat what they view as illegal financial activities taking place under certain corporate identities, and this will give them a way of closer tracking how that is going on. Next slide, please. So who is required to report? This is an interesting statute in the sense that typically, when you think about regulations, it's more larger corporations or more sophisticated corporations are subject to, feels like, more regulations than small businesses. But actually, this one works in the reverse. It is apt to small businesses with fewer than 20 employees and less than $5 million in gross receipts or sales. So if you fall within that category, you are one of those. You are a reporting company that will need to file with FinCEN under the CTA. And what you're required to file is called a beneficial ownership information report. And we'll talk about that in a minute. There are some exemptions from filing for highly regulated industries, banks, credit unions, and also some tax-exempt entities. And of course, larger companies are exempt too. Next slide, please. So the reporting, the filing deadlines for reporting for companies in existence as of January 1 this year must file their initial report by January 1, 2025. So you've still got time to do that. Don't wait because it's not a particularly difficult thing to do for many businesses, but there are, the potential is there, depending on your business structure, that you'll need to gather some information and consider carefully your reporting options. Reporting companies that were created after January 1, 2024, so this year, are required to file an initial report with FinCEN within 90 days of formation of the entity. So keep that in mind, that there are different filing deadlines based on when your entity was formed. Reporting companies must update beneficial ownership information with FinCEN if there isn't a change in ownership. Next slide, please. The information that must be provided in the filing is the company information, which you can see there. The thing that concerns, it presents a concern for certain entities, is personal information about any individual who is a beneficial owner of the reporting company, including legal name, date of birth, address information, and driver's license or passport. So there are some real concerns about this kind of filing in the context of disclosing personal information. There are potentially some workarounds on that you ought to consult with your attorney or a business consultant about whether that might be available for you. Certainly, we're hearing from a lot of our clients who have concerns about disclosing this level of information in what is a public filing. Newly established entities are required to submit this information upon formation. And again, if you're an existing business in existence before January 1 this year, you've got a little bit of time to report. Next slide, please. Beneficial ownership. It's a pretty broad term. Refers to individuals who, one, directly or indirectly exercise substantial control over the company, or two, who directly or indirectly own or control a significant portion, 25% of a company's ownership interest. But it's not entirely tied to ownership interests. The purpose of the new filing is to identify individuals who have actual power or derive significant benefits from a business. And so it goes beyond the names that typically appear on legal documentation for an entity. Ownership interest, again, is not required under the definition of who is a beneficial owner. And really, again, the purpose of the rule, just to try to make some sense of this, it's pierced through the layers of corporate structures, which are often, intentionally complex and opaque, to try to get at individuals who really hold power and are in a position to benefit financially from the entity structure. Next slide, please. Consequences of non-compliance. This is one that, just take note of this, that the penalties for non-compliance are significant. $500 a day, up to $10,000. And in some cases, we don't know exactly what that would be. Criminal charges are a possibility there. But, those fines add up pretty quickly. And so you'll want to be sure that you're mindful of this in the run-up for existing businesses, in the run-up to the January 1, 2025 deadline. We've been putting out all points bulletin for our existing clients to to not wait until the last minute to get to get in compliance with the CTA. And we will continue to do that for those of you who are considering starting a new business entity now. Just be aware that there's a 90-day window for that compliance. If that presents an issue, just take that into account in terms of maybe the timing of the formation of your business entity. Next slide, please. Now we get to the fun part. Happy to answer any questions that you might have. That's a lot of information to cover. I realize some uncertainties there in terms of where these things might go. Hopefully there will be some questions there. I'll be satisfied if there aren't any, because
I have questions, don't worry.
Okay.
So I'd like to start with the last one, the CTA reporting. You mentioned that fewer than 20 employees and 5 million revenue. Both conditions apply, or either one?
I think it's both.
So,
I mean, in other words,
so if I'm over 20 but below 50, but below 5 million, do I need to report?
Oh, I'm sorry. You have to meet both requirements. In other words, for filing, a reporting company is an entity that has more than 20 employees and more than 5 million in revenue. So you have to meet both metrics. So if you have fewer than 20 employees. Okay,
so I have more than 20, but less than 5 million in revenue. So do I file or not?
I think the answer to that is no.
Okay,
Mark?
so smaller companies, so smaller than 5 million companies that have, so basically if
if you have fewer than 20 employees and less than 5 million in gross receipts, you're required to file.
Sorry, I was on mute. I was popping along answering questions and no one was there. Sorry.
So I think it's an and. So you need to satisfy both of those in order to be subject to the filing. Does that make sense?
No, not yet. Sorry. So fewer than 20. Okay, so companies, the fewer 20 employees or less than 5 million are subject to filing, or larger companies are subject to filing. I'm missing them.
Larger companies are not subject to filing. This is one of those laws that works in kind of a reverse logic. It's subject to small companies on the theory that small companies are more subject to this kind of reporting abuse or financial abuse than larger companies are, which in most instances are already regulated in some enhanced way. So here it is trying to capture and enhance reporting requirements for small entities who are not subject to any enhanced reporting requirements, but they will be now.
And you're saying that both should be applied, employees and revenue, or either one?
Both. So if you're an entity that has fewer than 20 employees and you have less than 5 million in gross receipts or sales,
then you're required. But if you go over 20 employees, but still like at 4 million, you're not required.
And I don't think you meet.
You can hire your way out of it, basically.
That's what I'm asking. Basically,
it's counterintuitive. It really is. Yeah.
Okay. That's crazy. Okay.
And if you have any questions, we can follow up with you on that. But I think it is an and, meaning that you have to meet both of those standards in order to be subject to filing.
Okay, thank you. All right, so going to the salaries. In my case, we actually trying to convert everybody to salary, all like go away from time cards altogether. So that's basically not gonna work in the scenario with a
Well, I mean,
minimum.
it might. This is a really a kind of that is kind of an involved question that we might want to maybe talk about offline.
Okay.
So in order, really what we're talking about when we talk about the Fair Labor Standards Act is whether an employee, whether as a business you have to pay an employee overtime or not. So if an employee is exempt, as that's defined by the Fair Labor Standards Act, they can work as many hours during a week as you want them to, and they're not subject to overtime pay. But in order to have exempt from overtime status under the Fair Labor Standards Act, you have to meet certain requirements. Salary level, which means you have to pay them the same amount every week. There are a few minor exceptions to that, but you have to pay them the same amount every week, whether they work a lot or a little, as long as they work some during the week, and it can't be tied to their production generally. And they have to meet one of the duties tests in the Fair Labor Standards Act is either an executive, employee, administrative, or professional. And then they have to meet the salary level, which is really what you're talking about there. So you have to meet all three of those things in order for an employee to be exempt.
What if the employee is not, what if employee salary is not based on 40 hours per week? What if we have part-time employees that we still have on salary? They're not going to be making, that much.
Yeah, I think I better not jump too far into that because I think that you're
Let's
getting
wait
in the
until-
land of I don't want to give you any legal advice. It's a real
Okay.
I'd
Let's wait
love to,
until
but
it's actually
it's a really complicated area. But it's fair to say that that for an employee to be exempt, you have to clearly meet all three of the tests that are required. Solid advice here. I've been doing this a long time and do a lot of client work in the area of wage hour. It's a very dangerous area for businesses to be it's an important area for businesses to be careful in because the consequences of getting classification of an employee wrong for Fair Labor Standards Act and now local wage payment statutes as well is really significant. So my advice generally on that is if you have doubts, if someone is close, you have doubts about an employee meeting any one of those three tests that are required, you should probably consider treating them as non-exempt unless you're really sure that they qualify as exempt. Especially if the employee is going to be working a lot of hours for you because all of a sudden, hours start adding up. And if you're treating them as exempt from overtime pay, they're not getting any overtime. The hours continue to accumulate. And all of a sudden, if you've got a misclassification at some point after a year or two, you got a whole lot of money at some point. There are liquidated damages and attorney's fees at issue as well too. So it's a really I can't overemphasize it's a pretty hazardous place for businesses to be wrong in terms of classifying employees.
Yeah, in our case, it was for the employee benefit. They don't work any overtime and they would get unlimited PTO if they were on a salary. Like now, if that comes in place, I can't pay them full. I don't know if I can or not. I haven't looked at the numbers, but until like 2027, I probably can. But if you have to pay everybody like over 100 to be exempt, then it's not going to work.
Yeah, I'd be happy to talk with you about that. I think you've got there's a resolution there. It's not an easy one. It would take the next hour probably to walk through that. So I'm sorry, I'm doing the best I can to answer.
No, I understand. So last question, I'll let you I'll leave you alone. For the first topic, FTC, does it affect business to business, non-compete, non-solicitation or non-disclosure?
It might. I mean, again, it depends on the scope of the, I mean, in my reading of the rule, it depends on whether the restriction is the functional equivalent of a non-compete in that setting. Because remember, the FTC's idea of worker extends beyond, you know, what you would think of as a typical worker relationship, which is your employees, and it can extend to, you know, 1099 independent contractor, which would in essence be a business-to-business relationship. So I think it depends on what the scope of the restriction is at the end of the day. And I think that's primarily where Mark and I have been spending a lot of time advising businesses on sort of whether or to what extent there's a workaround of the FTC rule. And we think in most instances there is, but it will really depend on the wording of the particular agreement that you're looking at, that you're working with, and sort of narrowing the scope of that to the point where it still protects your business, but doesn't become so broad that it looks like it's anti-competitive.
So, and I don't know if
For
that's
small
the
businesses, I typically am not seeing that generally as a problem. For larger corporations, I think there's a real concern there.
like in our business, we have this non-solicitation or do not steal my employee basically clause written up, right? Because it happens. Clients like my people so much, they approach them to be hired in-house, like directly. So my concern is if that's gonna go away or not. Like, because right now, if that happens, we technically can get at least like 1 year's salary paid as a penalty or whatever. I don't know how enforceable that is, but
I think it depends on your particular agreement. You know, we are mindful of working with clients on the wording of these things, because I think the rule is still pretty new, and so we're still in some instances trying to figure out what a functional equivalent to a non-compete is. We'd like to think we know what it is, and I think we've got some, you know, in most instances there are effective workarounds, but I think it depends on the relationship and the particular terms and conditions of the agreement.
I thank you.
Anybody else?
Hey guys, Paul Dean here. Just wanted to first of all say thanks for a great presentation. As I said earlier, I get a lot of small business owners in here that are just confused, and I guess one of my questions, I guess you kind of answered, is on the non-compete. Does it apply to independent contractors? And I think the answer is yes. But there's some wiggle room or workarounds and things like that. The other thing that I wanted to bring out is less of a question, but more of just a word to the wise, or be out on the lookout. So with this, the FinCEN beneficial ownership information requirement, I'm starting to see some predatory companies out there trying to take advantage of the confusion surrounding this, particularly with small business owners and new LLCs. So I have several clients who have established LLCs over the course of the last few months, and about a month later they'll call me up in a panic because they've received a notice that looks like an official government notice, but as we've all seen, it's really a very well sort of tricky, hidden government type looking notice from a private company that is scaring them into essentially paying them to help you meet the requirement. You know, you have to send us, you know, $500 or you're going to be in violation. And you know, essentially they're soliciting their services to help them with the filing, which most people can do on their own. But there's also a lot of misinformation. For instance, you know, I asked one of the clients to bring in one of these notices, and you know, obviously it was kind of one of these fake things. But you know, they were saying it was you know, that they had to file within 30 days rather than 90 days. So there's just a lot of misinformation being fired off as people file new filings, and obviously it becomes public record, and you see all these notices that again, are cleverly disguised. So kind of, I would advise, clients and folks listening out there to kind of be aware and be on the lookout that there are some predatory folks trying to take advantage of the confusion surrounding this.
Thanks, Paul. That's great advice. Nice to meet you. That's great advice. And I think it's worth emphasizing again that for a lot of businesses, the filing is pretty straightforward. It's not really all that difficult. You are going to have certain business structures, though, that do have some nuances to them. There are some reasons for, various layers of, entity ownership, indirect ownership. And in those situations, filing can be a lot more complicated in a lot of different ways. So just take that into account. I think that's great advice. And there is a lot of misinformation out there for sure.
With that, we're sliding in just under an hour. So
Yeah.
give everybody back 3 minutes of their day back.
So Mark, do you want to add anything else to all of this?
Doug is the master.
Okay.
Anything it was Lincoln, mere mortals cannot add or detract.
You're so funny. Well, I know with the beneficial ownership laws, the Corporate Transparency Act, that's still being litigated. The National Small Business Association actually went to court, got an injunction that said it was unconstitutional, but only for their members. I can't understand that, why it's unconstitutional only for their members and everyone else has to comply with it. And
we are scratching our heads as well. With all of these three topics, there really are some legal uncertainties about, in the case of the FTC, whether it has the authority to make rules of this scope. And I think my best guess is at this point, Mark, I hope you may have a different view, but I think it's less than 50-50 likely that it survives ultimate review. I assume that's going to sort of perhaps run up to the Supreme Court.
I think the legal basis for it is sketchy, and I think to the extent not that the practical impact should merit into what the court considers, but the practical impact is
and it's
positive either.
Not to get too wonky about it, but it's that I think Mark's point, practical impact is so huge in the case of the FTC rule that the Supreme Court seems less inclined to give agencies rulemaking leeway when when it has that broad an impact. More than 100 million workers potentially impacted by that, or businesses employing 100 million workers. I mean, that's a huge impact. So stay tuned for more on that, but do keep in mind the state laws that also have an impact on how you operate your business. And also too, the National Labor Relations Board is lurking in the background and always ready to make trouble for businesses. So
well, we really appreciate your time and all of this good information. We'll go ahead and close unless there's any final questions from anyone. I think that's it. So thank you, Doug. Thank you, Mark. Really appreciate all of this good information.
Thank you so much.
thanks, Holly.
Thanks, everybody.
Take care, everybody.
Bye.
Bye-bye.